I'm Adam Rossin with the Rossin Law Firm, Federal Criminal Defense Attorneys. And in today's video, we're going to talk about the federal sentencing guidelines and how the Garland Memo from Attorney General Merrick Garland and his opinion in December of 2022 is changing everything. So before we go into what the Garland Memo is and how it changed the federal sentencing guidelines, I want to talk a little bit and go into the history of the federal sentencing guidelines. Now, prior to 2005, the federal sentencing guidelines were mandatory, which meant that all federal judges must follow a range that's within the sentencing guidelines. However, in 2005, there was a U.S. Supreme Court case called Booker, which held that the federal guidelines as a mandatory punishment were unconstitutional. And now the federal guidelines, the sentencing guidelines, are advisory, which means the judges can go within the guidelines, and they can also do either an upward or downward variance and go around the guidelines if they believe the situation warrants it. So that was the rule prior to 2005, is that the guidelines were mandatory, and from 2005 onward, they are advisory with allowing variances depending on certain factors. So now let's talk about what the Garland Memo actually is. So what it is it's a set of instructions or guidelines for Department of Justice, DOJ, and the assistant U.S. attorneys of how they're going to prosecute cases. So these are suggestions. These are, they're not really requirements because it doesn't change the law, right? The laws are changed by Congress. But what this does is this basically changes DOJ policies. Okay? And it really gives the prosecutors, what he did was he gave the prosecutors instructions on how to be a little friendlier with defendants and really examine cases deeper to see if the punishment fits the crime. That's basically what it is. And that sets forth the DOJ's policies and the procedures of how they're going to really examine these cases. So the Garland Memo is really about proportionality in sentencing recommendations. Now, this will affect drug cases significantly because just because there was a lot of drugs and there were, the person's being prosecuted based on quantity, quite oftentimes they forget about the defendant's role in the operation. Was this a large role, or do they play a relatively minor role, but there's large quantities of narcotics? And in this particular memo, it's instructing the DOJ prosecutors to really look at the facts and say, hey, if this person criminal activity was less proportional to others, well then a downward variance could and should be justified in that situation. So that's huge because it's bringing not just a human component and element to it, but I think a fairness component, because we've all heard the stories about a minor participant being involved in a major drug operation, and that minor participant is being punished as if he was the drug lord. And what they're doing is they're punishing that person, and they're really flexing their muscles to try to force him to become a snitch, to rat out other people, because they're going to put this completely disproportionate sentence on that individual, and it's not right. And so that's one of the main benefits that the Garland Memo is going to have in federal criminal defense cases. And the next benefit that the Garland Memo will have for defendants is in the career offender statute. And so what this memo states is that the prosecutors really should be looking at prior offenses and especially looking at non-violent drug offenses. And if they see non-violent drug offenses that are being used to categorize the defendant as a career offender, then they can either pull them out and not qualify him as a career offender, or they can still do that but then argue for a downward variance and really come to an agreement on a downward variance. And that's really good because instead of just looking at the categorical approaches, they're going deeper to look at the facts and circumstances of the case, which I believe everybody really should be judged by the facts and circumstances of their actual case. And quite often we have these nonviolent drug offenses that could involve larger quantities of drugs, but has nothing to do with violence, that is being used to punish people double, triple, quadruple of what they ordinarily should get because of these sentencing enhancements that are old and archaic back from our tough on crime days that have been proven to not work to reduce the recidivism rate for crime or to serve as a general or specific deterrent to crime. Now, remember, as I stated before, these are guidelines. This is not a change in the law. Remember, Congress changes the law. So the career offender statute is still there. These predicate offenses still qualify. This is just internal memorandums of what the DOJ prosecutors should be doing and how they should be analyzing the law and basically changing their policies and procedures. But questions remain. Right? What about tough on crime prosecutors that followed the previous way and don't really believe in what Attorney General Merrick Garland wants to do? Right? Are they going to cooperate? Are they not? Well, is there going to be any punishment to them if they say, yeah, too bad, these are guidelines and I don't care? Right? Is anything bad going to happen to them? What about the judges who are tough on crime? Are they even going to listen, or do they care? So there's a lot of things. Just because it's been a few months since the memo came out, we're now starting to see how it's really going to affect federal criminal defense and federal prosecutions and federal sentencing. So we're going to keep a close eye on this with all of our cases. Stay tuned, but we really hope that this is going to be a great victory and great help for our federal criminal defense. Now, if you have questions about this, if you have a federal case and you want to discuss, you can always give us a call, 754-206-6200.